Welcome, everybody, to this week's episode of the Self-Directed IRA podcast with yours truly, Mark Kohler and the amazing Matt Sorensen. Well, we're talking about self-directing, just directing your own life. You're in control, people. Don't blame anyone else.
Yeah. Who should care more about your money than you? Don't be lazy and just let Wall Street decide what to do with it. That's what we're doing here on the Directed IRA podcast, learning how to take control and invest in the assets you like. But at one day, you're going to die.
Okay.
And
well,
that turned quick.
Yeah, that turned ugly real quick. I wasn't thinking about self-directing money. I was just talking about people, in their AA program, their relationships. I thought this was going to be more of a touchy-feely show, but I guess we'll talk about money and death.
Yeah. Money, death, taxes, the fun stuff. So yeah, you are going to die. I hate to break the news to you. And someone is going to get your retirement account, your self-directed IRA or 401k, I guess all of your retirement accounts when that happens. So that's what we're going to talk about today, making sure you nail that process, get it down so that these pass on in the most tax efficient way, also in the most strategic way from an estate planning perspective too. Mark and I are both attorneys, been helping clients with their retirement accounts, doing estate planning, which our law firm has been doing for years. So we feel like we got some good insight on what you should and shouldn't do. We've certainly learned from our clients over the years on what works and what doesn't.
Yeah, what Matt's saying is we've learned from all of your mistakes, and we're going to air your laundry. We're just going to open the laundry basket up and just.
But we'll refer to them as client number 2 or client number 12. We will not disclose the true identity of these people. So
yeah. And I'm trying to get my camera here looking. So for those watching on YouTube, I want to make sure our heads are equal size because we discovered we were shopping for cowboy hats and Matt has a bigger head than mine. And I just feel concerned about him with his head down.
Yeah.
Now, look at that solar. It's got its own solar system. Look at that noggin.
It's like an orange on a toothpick.
We won't reveal our hat sizes. I actually think they're quite similar. Okay, now we are doing our estate planning special this time of year. And so a lot of people ask, should I have my trust be the beneficiary of my retirement accounts? And that's actually a harder question to answer than most would realize. 10 years ago, the government wasn't doing us any favors. If you put your trust as a beneficiary of a retirement account, it could actually be tax nightmare for your family. Yeah. So there's been some new laws passed. Don't listen to a financial planner that's older that says never make your trust the owner, because I don't think they are familiar with the law if they're blaming taxes. So but this is our annual special. We do estate planning. We're talking about the revocable living trust. Maybe we should talk about that option first, and then you've got your spouse, your kids, your mistress, your spouse, your kids, your mistress. I'm just throwing all those in there. Just
your Mister too. The Misters.
I meant Mister.
Yeah, there's some Misters out there that are hoping to get listed as beneficiary. Well, let me say this on first, that retirement accounts do not pass based on what you put in your will. Okay. Not even in your trust. You have to specify who's getting your retirement account on a beneficiary designation. So usually when you open up an account, there's a section, and here at Directed IRA, where there's a section, you got to say who's the beneficiary on this account when you die, who's going to get it when you die. And you can list primary, and then you can list contingent. And we have lots of different options, and Mark and I are going to go through that. But the first thing I want to say is a lot of people mess up because they're like, they may have set up a retirement account years ago and they don't even know who is the beneficiary on it. But they're like, well, I did my estate plan last year though. I did my will or my trust and I said who gets it. That ain't going to work. It needs to be on your beneficiary designation for your account.
Yeah. And I think it's good to say right off the bat here, for any of you that just your heart sunk in your chest going, what? I don't even know who I put. When you're enrolled in your 401k at work, you opened up a Roth years ago. You could have been single or married then. Now you're divorced. Now you're married versus. Yeah. So all those life changes matter, of course, but you can change it. Here's the good news. It's not a tax consequence. You don't
just
even
don't die yet.
Yeah. It's way cheap. You can just call, you just literally oftentimes go to the website wherever your financial instrument is, that Roth or IRA or whatever it is. If it's at work, you go to HR, but you can change it anytime you want. So
yeah, and if you're a directed IRA, it's just change of beneficiary designation form. It's on the website. So yeah, and we have it right there. You can complete online.
Yeah. Let's say you don't do anything, Matt. What happens if you don't do anything? Let's just.
Then it's going to pass. Then your IRA custodian and the 401k administrator is going to wait for a court order to say what happens to it. So, if you died without listing someone as beneficiary, maybe you had a will, maybe you had nothing. The court's going to have to appoint an executor, personal representative for your estate, and they're going to come tell us, here's who's getting this, and we can move it based on that.
I think that's a great one to talk about. Maybe I'm coming up with an outline for a blog article as we're talking here. But number one is I didn't list anything. So what happens? And it's much like Prince, who I wrote an article on him in the Minnesota court system right now, dying without a will and trust. And it's just been a debacle for 5 years going through the courts in Minnesota. So a court would have to say who gets your IRA. Okay. Yeah. And whatever your state's in, that law is going to control. Okay. Number two, let's say I was single and I named my parents, which is often, I think, the case. They'd say, well, mom or who?
Yeah. If you never had kids, you're single, never had kids. Yeah.
Yeah. So you're single, you never had kids, you name your parents. You may name your special favorite lawyer and podcaster just because he's changed your life. That would often be a very typical.
Yeah.
And if you have a podcast with two lawyers, you'd choose the better looking one.
I thought you were going to say go 50-50.
Oh,
because I didn't want them to list me entirely. I didn't think you'd cut yourself out automatically there.
Well, it's beauty is in the eyes
See
of
what
the
I did
beholder.
there?
Yeah. Maybe you're right. Maybe I should be more careful there. I'm going to hedge my bets. Okay. Well, let's say I named my parents and I was single. Can my spouse come in and go, whoa, he's married now, or she's married now. He or she should have never done that. I'm going to make a spousal claim and take the parents to court. Can they do that?
Absolutely. And now then there's going to be a debate of whether that retirement account that you had was a marital asset. Now, here's going to be the problem. Even if you're like, but I started that account before I was married. Okay. Did you keep investing it and keep contributing it to it from the marital estate, from your joint checking account or any of those things? Now it's a marital asset, even though you may have had it before. Now, maybe you had a prenuptial agreement or something like that that could have cleared that out. But if you didn't, your new spouse here, even if your intent was that your parents would get it or whoever you listed before, spouses are always going to have a spousal claim. And in most states, it's up to at least 50%, if not the entire amount. And I've actually been to probate court litigating those issues back when I, was crazy enough to do litigation. And it was only limited stuff, but man, the probate stories are crazy. So yeah, there's a spousal claim, and we're going to get into that on the beneficiary form. In fact, if you do not list your spouse as the primary beneficiary and you are married, your spouse must waive that in order for it to be valid. And I'll go through the process and we'll talk about that more. So if you're married, you got a lot of things you got to do to list someone other than your spouse as the primary beneficiary.
Your spouse is going to know about it. That's the key.
They're going to have to consent to it.
Yeah. Now, life insurance is a different story. For you out there that say, I'm going to go buy some life insurance and name a friend or a family member or a very, very close, intimate friend that no one knows about as your beneficiary for your life. Gosh, I feel very dirty today, just giving these really bad examples.
Salacious,
No, but there was an example. I tell this story all the time, and it's true. It's a court case in California. It's about 5-10 years old now, and it happens all the time. But it was one that actually went to the Supreme Court of California. There was a guy that died out on the golf course, and he didn't have a mistress, happily married, whatever. But the life insurance policy listed his first spouse from like 20 years before. And his current spouse went to go claim the life insurance, said, hey, I need the money. And they're like, well, so-and-so's getting the money. She was listed. And she goes, oh, well, I'll solve this. I'll just give her a call, let her know it was a mistake. And I'm the current wife. That call didn't go as she had hoped. And so she ends up going to court and all the way to the Supreme Court of California. And they go, was it a mistake? You don't know. Yeah. He's dead. And so the first spouse designated on the life insurance got it. Now, retirement accounts are different. And you may have a whole life insurance policy that has ongoing contributions or a cash value that was contributed to was in marriage. I'm sure there's some lawsuits that would be, the fact patterns might end up a little different. But
now let me complicate this. And this is Matt, the lawyer, coming in here, just trying to make it complicated for you. So I'm sorry, but I think this detail could help some people. 401ks, solo 401ks included, they're governed under federal law in terms of retirement plan rules. And federal law basically says, if you want to list someone as the beneficiary on your retirement account that is not your spouse, they must sign a consent form, all right, in order for it to be valid. They've got to consent to it.
So IRAs are state law, 401ks are federal.
Exactly. Now on the IRA side, IRAs are operate under state law in terms of when you die. I mean, they're federally created, right? But they pass under state laws. Now there's about 8 states, particularly community property states, that specify that a spouse also has to waive it passing to someone else if they're not going to be the primary beneficiary. So you could be in a state that's not technically community property, or it's an IRA, where you could get away with not doing a spousal waiver, maybe. But most companies are going to make you get a spousal waiver if you want to list someone else besides your spouse as the primary beneficiary. And that's always a good rule of thumb when in doubt. So I can see someone coming to me and say, well, Matt, in my state, you don't have to have your spouse waive it. Okay, great. Does your spouse know that? Are you sure your spouse isn't going to make a claim on this when you die? Because let's just get that taken care of now if there's any doubt about that.
Yeah. Well, if they're like, well, I don't want my spouse to get it and I want to make it hard for him or her. Okay. Just know it may not be 100% effective, but it definitely will make them jump through some hoops. That's for sure.
Yeah.
Now, okay. So let's say number 1, I didn't list anyone. Number 2, I listed someone other than my spouse. And now there might be a claim in court from that spouse for that amount. Why don't I just name the trust and let the trust just figure it out? If I'm married, then it'll say, here's the primary. And if I'm not married, it'll say, here's the just let the trust. So then I only have to amend my trust once in a while. And I don't have to go through all these different accounts on a regular basis if something big happens. What do you think?
Yeah. Well, here's what I think. I always like listing spouse first. If you have one, as long as that's what you want, right? And if you don't, then just, remember, you're going to go down this spousal consent thing we talked about here already. But as a general rule of thumb, it's nice to list your spouse first, then the trust second. Again, if you got one and you want your spouse to get it. The reason for that is when you pass away, there's retirement account rules that say your spouse can inherit your account and do what's called a spousal rollover, where they don't take an inherited IRA when they get your account. They get what's called a spousal rollover. It just rolls into an account in their name. Or if they already have an account, it goes into their existing account. All your assets just get moved over to their account. It's all passing under the account rules under their name. You don't have these inherited IRA rules now, which make them drain it within 10 years. It's just nicer because it can go to them as spouse. Now you go ahead.
If I may comment.
Yeah.
Now, the federal law that was changed in the last 7 to 10 years is what's called the see-through provision. So if you don't name your spouse, or your spouse has to do a fight to get it, and he or she gets it, they're still going to be allowed to do that spousal rollover. And the trust says if you have this see-through provision in there, but I think my opinion, Matt, would be that by naming your spouse, you make it a heck of a lot easier, because then they don't have to go to the trust company, the custodian, the broker, the bank, and say, hey, let me prove that I want to do a rollover with some verbiage or this, that, or another. It's just boom, done. But it's not fatal, is what I would say. Would you agree with that? Because of this see-through provision in the trust?
If you listed the trust first and the spouse was the primary beneficiary under your trust.
Yes.
Yes, but my only hesitation to that is if you list your trust as the primary beneficiary, you're going to need to provide a whole copy of the trust. Okay. You're not going to be able to just send your certificate of trust or anything, because your IRA custodian or any retirement account must have on record the name and who the heck the person is that's your primary beneficiary. So we have to be able to find that and see that in your trust that, yeah, my spouse is the primary beneficiary when I die of all of my assets. It'd be nice if it identified the retirement account, but it doesn't if it says all of my assets. And so that's possible to get away with it. I was just going to say, just as a retirement account, is someone in that business, when someone lists their trust first, we always say, send us a copy of the trust. They don't.
Yeah.
I mean, it's just like we pull our head out and it's like, now I have a beneficiary form that doesn't work. You listed your trust. It ain't valid. If I don't have a copy of your trust, it's not valid.
Yeah. Now this is where we get into what we call the trifecta over on Main Street Business, if I may interject. So all this trust talk, some of you may say, well, I don't even have a will. 50% of Americans don't even have a will. If you're listening to this show and you don't have a will or a trust and you're building wealth, this is something you got to deal with. It's not worth the cost and the headache and the amount of money lawyers will take to milk a probate. And we're not probate lawyers, so I'm throwing some stones. I know someone will send me some hate mail, but divorce lawyers and probate lawyers, it's not always in their best interest to have the divorce over or to have the probate over, because they're billing on it. You know, there's no incentive to get the probate over when you're a probate lawyer. So what I'd like to do is encourage all of you, get that trust. And when you do, we have a funding paralegal that is different names over the years of different funding paralegals have worked in that position, and then they get promoted or move around in the organization. But this funding paralegal is going to help review all of your entities, review your retirement accounts. Well, not so much get the paperwork from you and review it piece by piece, but they're going to say, what do you got? Let me help you get this done. Here's where you go to do this. Here's where you go to do that. And there's some small fees, oftentimes half off during that first 3 months after you sign a trust. So maybe a shameless plug there, but they go hand in hand. You want to get that trust finished at the same time you're reviewing your beneficiaries.
Yeah. And let me make one other note on why I like spouse as, again, if you have one, and that's, you want to get it as primary and trust second. One of the reasons of using a trust is when you die, if there's creditors that your heirs may have, is they can't get into the assets of the trust. The trust can say, nope, we're not going to move the assets to that beneficiary. Let's say your spouse that maybe has a judgment against him or her. So you're like, well, I don't want that. That could put it into jeopardy. Well, the retirement account is safe from that anyways. So you don't need the trust to protect from creditors because the retirement account is already creditor protected, unlike some other assets you may have. So in some ways, a lot of the reasons we have a trust, creditor protection, for example, so that your assets just don't go to an heir who has judgments against them and it goes poof and gets collected on by creditors. The retirement account is sheltered from that already. So that's another little unique aspect of a retirement account from other assets. So not that helps.
You know, and if some of you that have already, I hope many of you that are regular listeners have persevered through this topic. And you're probably like, okay, I got it, guys. What's the big deal? Let me make a couple of important points that some of you be like, what is the big deal? Why are you even talking about this? I'll give an example. Let's say you have his, hers, and ours. So you're in a second marriage. You build up a 401k or IRA. Now you're married to a new person and you didn't do the prenup thing. It was a little awkward. You didn't feel like it. We're like, hey, we're going to share everything. And then you sit down to do a trust and you say, well, why don't I give my retirement account to my kids? You give your retirement account to your kids, and we'll split the home, or we'll split the business, or we'll split this. And you sit down at the kitchen table and you start horse trading because you've got this blended family. And you start saying, okay, let's put in the trust. You get this, and your kids get that, and my kids get this. It doesn't matter. It doesn't matter. Because if you don't make this clear in the beneficiary designation or have your spouse sign a waiver that they agreed to that, whatever you decide at the kitchen table is going to be in court, and it's going to be jacked up. And so when you have a blended family, just know you're going in with your spouse doing a good thing. It doesn't have to be the prenup conversation or the postnup that's really awkward. You can say, hey, I want to take care of your kids. I want to take care of my kids. We're now married. We're building wealth again. You got an old IRA. I got an old IRA. You got an old 401k. I got an old 401k. We got to figure out where the hell this is all going. Because if you die tomorrow, I want to make sure your kids get what you want them to get, and vice versa. And then it can be very collaborative. And you sit down and go, okay, let's get our joint revocable trust. Let's review all the accounts we have. Let's sign spousal waivers where needed, and let's nail this thing. That's why it matters.
Yeah. Yeah. And still, it's $30 trillion in retirement accounts, obviously. So this is like such a huge amount that gets passed on to your loved ones. And so we just want to nail it. The nice thing is it passes under beneficiary designation. It's actually pretty easy if you get it right. Like, just fill out the form, right? Get your plan set. Okay, let me go over another variation that I get of what people want to do. And just another thing to think about. Okay. Sometimes we get clients, and it's not so much the spouse as it is like the kids. They're like, well, what happens when I want to just list my trust, but what happens when I die? And the trust, is going to say my kids get it. How are they going to get it? Are they going to get inherited IRAs? Is the trust going to be involved anymore? Because I want all these protections. I don't want them to get all the money immediately. What happens with my retirement account? All right. Now, this is actually quite tricky, and it takes additional planning. And for retirement accounts, you're going to need to do some additional trusts and planning if you want the full Cadillac, control everything from the grave structure. Okay. The basic revocable living trust, like what we're doing, that has the see-through trust provisions that Mark talks about, that'll let your retirement account have your trust listed, and it will pass it down to, let's say you have 3 kids. So 1/3 is going to go to each kid. Well, they're each going to have an inherited IRA. They'll each have their own inherited IRA, and they're going to get 1/3 of your account. Okay. But the trustee is going to have to determine whether to send the money to that account or not. Now, at that point, let's say you have a provision in your trust that says, I don't want my kids to get anything if they got a drug or alcohol addiction, or if they got, whatever restrictions you put in there. So the trustee is going to have to make that determination when they go fund this and let these inherited IRAs get created. But once that money's in that inherited IRA, your original trust is not going to have a lot of controls. Your trustee is not going to be able to control the levers of the distributions without a new trust and an additional trust being included. Sometimes these are called IRA trusts, which we've done. And this is an additional document. So if you want control again during the 10-year life of the inherited IRA now, because that's the rule Mark mentioned now, this is under the Secure Act, inherited IRAs have a 10-year life. You've got to really have an additional trust that will be the owner of that account for that specific child. And then you can govern how the money goes out over that 10-year window.
Okay. Now, some may be asking, well, what the freak? Do I need that? Here's when you need it. If you are married or single and have kids under age 18, or kids that act like they're under age 18, that's when you need to think about this. And you go, well, if I die, my spouse gets it anyway. Sometimes a husband and wife die in the same accident. I know it's fairly rare, but that's what you're planning for. And when you say, oh my gosh, I don't want to spend the extra $1,000 or $2,000 or whatever to nail all this down. Well, you've got a little 16-year-old daughter or 16-year-old son that you love to death and love a lot. And you and your spouse die. And now you dropped a $500,000 IRA in their account, in and they can do whatever they want at age 18. Is that what you were thinking? Probably not.
Yeah.
And you're going to be up in heaven looking down, freaking out.
Yeah. So you got to be careful with that type of planning. And I will say that I've helped a couple clients over the years do them. It's not something I do anymore, but some of the older lawyers in the firm can do it. These are unique trusts. And so if you do have a special needs child, or you do have like Mark said, an adult child who acts like a kid still, but that you still want to get a retirement account, you're going to want one of these special IRA trusts. Also, I've just had clients have really large accounts that still want a little more control over it, where they're not entrusting it to their kids yet. So you could do it in those scenarios. I don't think the typical person necessarily needs to do it. You are going to have this check of time where the trustee is going to say, all right, am I going to let these inherited accounts get created and let the kids have them? The trustee's going to have some controls in your estate to say, maybe I hold this money back or maybe we distribute it out and just pay the tax now, and I'm going to control it and control the distributions. So you can have a little bit of check still from the trustee to determine whether those accounts stay on as inherited or the trustee keeps them within the trust and distributes them out in a different way.
Man, I love that. I'm sitting outside, for those that are watching on YouTube, in my little courtyard here in California. And I just reached over to this little herb garden and grabbed this. It smells so good.
What is it?
Well, I'm in California. So what do you think an herb is? Yeah. No.
Yeah. Is that cannabis? I didn't think that smelled great.
Oregano. This is basil, and I love some good basil. It's an heirloom tomato and some balsamic vinegar. Yeah, no, it's not cannabis. That's another episode of our show, Main Street Show. One other thing that you can think about too. Let's just wrap this up. Maybe I know we can beat it to death, and everybody's situation is so different. But one other thought is you can say, okay, I've got some older children, some younger children. We've got his, hers, and ours. As long as you sit down at the kitchen table and you carve it up with what asset is best for which child, think of it that way. So say you've got an older, you've got a blended family with some older children. Say, you know what? They benefit most from an inherited IRA. They're smart. They know what they're going to do with it. It's a Roth. It's this or that. And let's designate the retirement account to those kids. Then this real estate over here, where they're younger, we can designate that real estate in trust for them, where there's no custodian involved. There's no timeline. The trustee doesn't have to hurry and rush to get it out before the the IRA rules run out. And so that's okay. And I have clients who do that. And I was going to just say the family farm. I have clients that are like, well, I want, this is the Oklahoma, Nebraska, Idaho thing. I got to have the oldest son. He's running the farm. He gets the F-150 in the on the farm. Well, what do the daughters get? And it's been this is kind of a male chauvinistic farming world at times where, this oldest son is running the farm, and it makes sense. They want to keep it in the family for generations and generations. And see, this is one thing John Dutton's going to do. He wants Casey to have the farm, and a little Yellowstone reference there. And
but Beth would be a train wreck. Beth.
Beth will tell it tomorrow. Yeah,
she'd be a train wreck. But
yeah, and she even told the kids, I don't want it. But this is where you can get creative and say, okay, I'm going to leave the family farm to this child, but I'm going to leave the retirement account to these kids, which is fair. Or you're trying to, again, spread the dominoes around the board. So I think that's this is why this conversation is so important too. And then you review it every 5 years or so. That's it. When we amend a trust for a client, it might be $500, just a 1-hour appointment and a quick amendment. Just review it every while. Now if you have a major change, you get divorced, you get married, a kid dies, a spouse dies, you want to run in and make some changes and adjust it. And it doesn't have to be a $2,000 or $3,000 experience redoing everything.
Yeah.
So,
yeah. Yeah. You can always update the beneficiary designations. And for any of you who are thinking, crap, I probably need to update mine, or I don't even know what's on there. Just go back to your retirement account company, wherever your account's at, and go see who the beneficiary is. And like we said, everyone's got a change or updated beneficiary form that you can use.
Well,
all right. And I'll say this too. We do have a totally separate episode on inherited IRA accounts. So if you're going to be on the other end of inheriting an account, maybe from your parents or other loved ones, or maybe you already have, or you're in the middle of this having to deal with it, we've got a separate podcast episode just on that, inherited IRAs and the rules on those. So go check that out.
All right. Well, thanks everybody for listening. Please consider getting over to our Main Street Business podcast, our sister podcast, once a week. Just on your favorite app, type in Main Street Business. More broad topics on investing, small business ownership, getting out of debt, privacy, asset protection. This show, tax planning. Oh, yeah.
Yeah.
NBA playoffs, baseball, everything. So get over there and thank you for listening. Yeah. We appreciate it. If you enjoyed the show, please give us a 5-star review, and it helps others find the show. And we'll see you next week for another exciting episode of Self-Directing Your Life.
Stay calm, self-direct on.